for humanitarian actors. So maybe they are not being criminalized, but since still they restrain themselves in their actions because they cannot reach to certain entities such as the Islamic State, while they are an organized armed group. And for humanitarian actors, it's absolutely key to speak to these organized armed groups. So you see, this is the context and what we are going to talk about today. And to talk about these topics, we have two stars with us. So we have first Special Rapporteur Fionnuala Aoláin, who is really the Special Rapporteur for terrorism, human rights, and humanitarian law. I mean, each time I've read your reports, I was thrilled. And I was like, wow, this is exactly the problem. And you're always able to give light and to show the inherent problem in those measures. So we are really very honored that you are here. We are also very honored because Professor Fionnuala Aoláin is doing a fellowship at the Geneva Academy and working on a book on transformative occupation. So we are going to also to read your book. We look forward to that very much. And I don't know how Special Rapporteur is doing that, but she's also a professor in 2 universities, in Minnesota and at the Queen's University in Belfast. So I don't know how you managed to have these 3 lives together, but that's really impressive. We have also with us Judge Kipfer. Judge Kipfer has had a tremendous experience. He was the Ombudsperson dealing with the persons who are listed as members or as associated with the Islamic State or Al-Qaida or other associated groups. The Ombudsperson position has been created in 2009, correct? And so you have been appointed in 2018 for 3 years.
3.5 years. Yes.
3.5 years. And it's how did you survive? We will discuss that, because I mean, that's a very, very difficult position, very tense, I can imagine, politically. And that's the Ombudsperson is the only recourse for the persons being sanctioned. They cannot go in front of a court at the domestic level. They cannot go in front of a court at the international level. So their only solution was you. So Judge Kipfer has also a very long experience as a judge in the Criminal Federal Court in Switzerland, in Bellinzona. And now you are back in the beautiful city of Bellinzona, and you are going to tell us about your experience. So the objective today is really to have a conversation. So I will ask you both various questions, and then we will have plenty of time for questions and answers at the end of the session. So I will start with a question to set the scene, and which is really about the overall theme of the topic today. So what are, in your view, the main implication for human rights and for IHL or humanitarian actions more broadly, when we look at those counterterrorism measures and sanctions in particular? So we'll start maybe with Fionnuala, and then we will turn to Judge Kipfer also to have some illustrations through very specific cases where we can see what are the actual challenges. So Special Rapporteur.
So thanks for being here, and also it's a real honor to be a member of the Academy as a visiting scholar for this semester, hopefully to write a book if I don't get distracted by my work as Special Rapporteur. I think what I would like to start by noting is what we have seen is this enormous, vast and ever expanding proliferation of counterterrorism measures since the events of 9/11. And that expansion has really been at the core, addressing that expansion has been at the core of the mandate's work. In some ways, it's important to note that the mandate was created in 2005 as a direct response not only to the proliferation of legal measures to counter terrorism, but the abuse of those measures, particularly in the context of rendition and torture, which is the subject of my report to the Human Rights Council on Monday when I come before the Council. But what I would also stress is that what we've seen, in addition to proliferation and abuse of measures, is what I see as this nefarious creep of counterterrorism into global governance, into the UN system, into other entities. And I think one of the challenges we see is that counterterrorism is often seen as a quick solution for a complex set of problems, but often those solutions fail to address the root causes of the production of violence, and ultimately, I think, fail to keep us safe. They don't do their job very well. I've made the point consistently, as have my predecessors, that as we see this proliferation of measures over the last 20 years, we've made the point that those measures are only effective when the measures are international and rule of law compliant, so that effectiveness and security in some sense and human rights protection go hand in hand. And maybe to say, as Daniel, I'm sure, is going to talk more broadly about targeted sanctions, I think the mandate has been really consistent with the expanded use of these measures, these sanctions measures against individuals and entities. And that has occurred without a comparable growth in the kinds of procedural safeguards that are needed to ensure that those measures have national and international both legitimacy and human rights protection. And I think one of the things that I've said, and I've said it in the context of my report to the Human Rights Council last year, is that we need to look beyond the impact of those measures on the individual, who's the targeted individual of sanctions measures, but also to look at the broader impact, particularly on families and communities. And my report to the Council last year looked at the way in which targeted sanctions inter alia really impact the lives of women and girls in ways that are not well understood by virtue of this kind of broad impact of sanctions measures across that move out from the individual and apply to those around them. When sanctions are put in place, and I think this is one of the things the mandate sees, is we see, even though the target is often a male member, head of household, that we see it having this kind of cascade effect on all those around them. The individual who's the target ends up often being unable to secure work, here can't rent or purchase a home, they can't travel, there's criminal liability for seeking any kind of assistance, and there are limits to legal remedy. But at the same time, the women, the family, the children around that person are actually kind of in the shadow of all of those things and experience those harms in a secondary form, but often also are themselves the subject of additional sanctions by virtue of their association with the person who's in the mainframe of the counter-terrorism measure. I think the other thing we've seen, and this is where I'll close, is we've seen an enormous impact from this proliferation of measures on civil society more broadly. That counterterrorism is encroaching upon, shrinking, and in some place choking civil society in multiple countries around the world. And we've seen this happen because in so many countries, there's no, the definition of what we know, there's no globally agreed definition of terrorism. States get to define for their own domestic purposes who is or is not a terrorist. And the result of that is that we're seeing a consistent misuse of CT measures by virtue of these open-ended definitions that encompass all kinds of other actions. And so I'll close with that and note that on the issue of sanctions, we're launching today a report or a position paper on sanctions from the mandate to really document some of these broader measures and some of the structural issues we've been seeing. And we look forward to discussing them both with Daniel, but also more broadly with many of you as we think out these issues.
Excellent, thank you very much. So Judge Kipfer, would you like to tell us more about some specific cases you've been dealing with, or more broadly about the impact from a human rights law perspective of those targeted sanctions?
Maybe both. For in general, only a few remarks from my side. It's about listings. I was working on delisting cases. Most important insight for me, if you want to improve due process in sanctions context, you have to improve the listing decisions. That's maybe most important, and that with regard to the quality of information at the basis of listing decisions. First, I would like to stress that I do not really have an overview on counter-terrorism in a broad sense. I was working on single cases, specific cases, so it's possible to make conclusions, inferences from these cases to the general. As I said before, it's about the quality of information, and there is one big difference in designations, depending on whether the designation came from US it's exclusively based on intelligence, or from a European country. There it's always based on a criminal investigation, an indictment, and a conviction. And that's completely different also for my work. In the second class, in the second group of cases, I had always judgments with a reasoning about the facts. I could discuss these judgments with the petitioners. They knew what the allegations were. They had the right to express themselves about. And it's completely different in cases where the designation is based on exclusive intelligence information. That's for the moment. In general, I can confirm that there is a lack of due process, of fairness, and of transparency. That's what I was engaged for, to work for due process, fairness, and transparency. That was the notions from the resolution. And there are obvious problems. If you allow me, if I may, I would talk a little bit about two specific cases.
Correct.
I would start with my last two cases. Both are mentioned in my last report to the Council, the annual report. I had to draft 2 reports each year to the Council, and there I had the possibility to give observations, comments about what is going on, about the lacks of listing decisions, about the lack of due process also in my cases. So the first one is, both are mentioned in my report. So both have been delisted last week based on my last comprehensive reports to the committee. That's something like a judgment about the case. Comprehensive report submitted in December before I left the office. So it's possible for you to put it together. It's confidential, but based on the report to the Council and the fact that both have been delisted last week, you can put it together. So the one is the Abdel Malik case. Abdel Malik was a young man from 23, had 23 years when he was arrested in Near East, in a country, Middle East, officially based on information from the police, so national police information. There are also reasons to believe that before his arrest, the authorities of that country had been informed by intelligence, but we don't know. So he was arrested on national allegations. He had a phone and he had a passport. He was arrested on the airport. And then he was investigated and interrogated about the information on his phone and in his passport. And he was more or less candid, but the problem is all of that was under torture. So the information at the end, he was 2014, he was convicted by the military court of that country. All counter-terrorism proceedings are in the military court of that country. He was convicted for 4 years, and then he was expelled to his home country nearby, 2016, 2012 arrest, 2014 conviction, 2016 he was expelled to his home country, and he was there completely isolated. He didn't have the right to work. He spent his time together with his mother and his wife in his apartment. He never left. He was completely isolated. And so information based on torture, in substance, he was candid to me. So I think his listing was correct. But in substance, he was candid. He was acknowledging that in general the allegations were true, but today is in a completely different situation. So the recommendation was to delist. And for us here to to confirm that all information I have are with the consequence that his listing is based on information gathered under torture, and that's a UN listing. The second case, if you agree, I would read what I wrote in my report to the council. You see, it's online, so it's very transparent. It's published on the website of the Office of the Ombudsperson. That's the second case. It's about Mr. Al-Qaida. He was a Yemeni politician. He was listed based on intelligence. In one case that was considered during the reporting period, it became clear that the reasons for the listing of the petitioner and the requests from different states to maintain the listing were based exclusively on the intelligence information. It could not be established whether the information had been collected by the intelligence services of different countries or had originated from one source and been shared by that source with the services of other countries. The information was once again submitted during the Ombudsperson process. Same information was submitted again. The quality of the information is poor and is a cause for concern. Also, important parts of the allegations against the petitioner were investigated thoroughly by the authorities of the petitioner's home country and were not confirmed. The states involved are simply reiterating the information already disproved in the national proceedings. In addition, the information has not been subjected to a plausibility check. It has not been considered or even acknowledged that the allegation thus appears to be highly improbable and implausible when set against the background of publicly available information about the petitioner. Some pieces of information are obviously wrong. For example, one country informed me that he is still living in his home country and still working together with Al-Qaida from there, but he left his country 4 years ago. So, obviously wrong. Other aspects of information are based on poor understanding of the conflict in which the petitioner was involved. It's a Yemeni conflict, and it's about the relation of official government, army, Houthis, tribes, and Al-Qaida. It's very complex. It's a very complex conflict, and my impression was that the intelligence was based on a really poor understanding of what is going on the ground. For example, a government military training camp was attributed to Al-Qaida, even though it could not possibly have been under the control of Al-Qaida. Another possible, it was an official camp of the Yemeni army. For another possible explanation, also the Ombudsperson does not have evidence of this, is that the allegations were planted intentionally, possibly as an act of revenge against the petitioner. He was a politician. Yet another less serious but still troubling explanation is that the biased interpretation of or insufficient knowledge about ambiguous political and military conditions on the ground lies at the origin of the allegation. That's the second case. So
it looks arbitrary.
Yes.
So let me continue with a few questions to you regarding your experience as an ombudsperson. What were your biggest satisfactions? So from a very personal perspective, what were your biggest satisfactions and frustrations? Because I can imagine that when you review cases like that and you see that it's completely arbitrary, what was your feeling based on that?
So frustrations, not a lot. Some
No?
frustrations, yes. But I think satisfactions are much more strong for me. So firstly, it's we have a review mechanism which works.
Mm-hmm.
So as you maybe know, 2/3 of all petitions are accepted. So in 2/3 of all cases, the result is a delisting. That means that what the ombudsperson does is at least very important for petitioners. And that's a source of satisfaction. But also in cases where the listing was denied, I got, for example, from a US lawyer who was involved in these cases, very positive feedbacks about the fact that his clients, the petitioners, were happy to have the right to be heard, to be in a proceeding where on the other side of the table sits a person, the ombudsperson. It was me the last 3.5 years, but before my 2 predecessors, discussing with them the allegations and to give them the right to explain themselves. And so that was important for both of them, that they had this opportunity, and for both it was a reason to get a little more confidence what is happening. So the right to be heard, that's maybe a misunderstanding, is not only a formal right, it is personally very important for indicted persons, or here not indicted persons, but persons under allegations. And if you talk to them, even in cases where at the end there is no way for the listing, you will understand that things are different, very different than you thought before. So, and that's always my experience also as a judge, talking to indicted persons is always surprising, because it's always different from what you believe after having read an indictment. So frustrations, yes, there are some frustrations, but not personal frustrations. There was an article in Foreign Policy. I don't know if it was a journalistic technique to begin with my personal frustration, but it's for being interesting for the readers. But that's not what I meant. So I gave him some examples. What are the consequences of my contract I have with UN? And these examples are really, it's sometimes it was really ridiculous, but that was really not the main experience I had with on the job. So the problem of my contract, also my successor had the same now as a contract as an expert consultancy contract. So a mandate. The problem is that the ombudsperson is institutionally not independent. That is what I was arguing for, and unfortunately it was not possible to convince the council to work on that. It was also a proposal in my last report. Again, It was a proposal from our side during informal discussions with committee members, but it didn't work out. So that's, if you want to have an overview about, very good, an overview, yes, about discussions, renewal of the mandate and the new resolutions, there is on the website of Security Council report, there is a summary.
Great.
And it's not really, I was not really happy when I read it.
I wasn't happy either. We were both not happy.
Okay.
Well, we will talk about the renewal then a little bit later.
Maybe one
yes.
one aspect more about frustration. I talked before about the quality of information at the basis of listing decisions. That was sometimes a source of frustration. I have to admit. But if there is not enough information, credible information, reliable information, the result will be a delisting. There is an informal presumption of innocence, if you want to say it like that. So it's not so bad with regard to the petitioners, but there is a problem, and the source of my frustration, there is no improvement. And I would like to give you one example. It is with regard to a European country with a long tradition of due process, with a very high standard of judicial work. So courts are working on a very high standard in that country. But when it comes to the Ombudsperson, I am not in contact with courts. I am in contact with, I don't know, it depends on the country, intelligence authorities, police. So I got an answer from that country several times, the same answer about the question it was a designating state, about the question whether to delist or to retain on the list. And the answer was the following: we do not have updated information. That's why we believe that the reason for listing remains. So, and letting open whether they tried to get updated information or not, I'm sure they didn't. So doing nothing is enough for retaining someone on the list. And that in the context of preventative measures, which are only legally acceptable if the reasons are still in place. The reason for prevention. It's not punishment, it's prevention. So that was the answer of a high standard European due process state.
Yeah. Thank you very much. No, it's very enlightening. And so when we think about this role of Ombudsperson, we see that you had, successes, and the role can be successful because people get delisted. But still, you highlighted the issue of independence, and we can definitely consider that it's not an effective remedy, right? Because even if you have most of the time the possibility for the person to get delisted, the Ombudsperson does not have the decision power to delist, right?
That's true. Formally, traditionally, it is not a remedy, but it's effective anyway. So it's an effective remedy.
You're playing with the words, isn't it?
Yes.
But do you think there is space to have something that would be a real effective remedy from a legal perspective? Is it imaginable to have a court at the UN level to delist, that would be in charge of the delisting process?
I can imagine, but I'm not very optimistic. So my imagination is always possible. but the facts are against. So I'm not optimistic about the perspective on whether the Security Council will create a court. We are talking here about counterterrorism sanctions, but there are other sanction regimes, and there it's even worse. Because there is nothing. So and you can imagine if information basis is so poor here, it's maybe not different in other sanction regimes. So Security Council, I don't think that the Security Council in the next years will accept the creation of a court.
No.
That was the proposal 2008 from Germany.
Okay.
Germany asked for a court, and the result was Germany.
Okay, I see. So not too much hope to have in this direction.
Maybe it's possible to show one slide here. Which one? Next. Yes, no. One more here, yes. Most important aspects of the Ombudsperson procedure, so achievements. But as we said before, it's not a judicial procedure.
No, it's very clear. Thank you. Let me turn to Special Rapporteur now, and let's talk about due process. You have very often highlighted the importance of due process, and this being at the national level, but also at the UN level. So why do you think due process is so important from a human rights perspective? And what could be done at either the international level or at the state level to improve that?
Yeah. No, I mean, I also just want to acknowledge, as Daniel has finished his remark, what an extraordinary role Daniel and his predecessors have played, the incredible professionalism of the office, which works in this very difficult space, a political space as well as the legal space. And I also just want to concur with his observations, not so much obviously the mandate doesn't see the individual cases, but the observations around the sourcing of this information, which is a broader problem that we see in counterterrorism processes generally, where the basis of evidence are these sources that are not revealed, and the implications that has for the integrity of the process and the reliability of the process, and ultimately the legitimacy of the process, I think are really well said by Daniel. And I also would just underscore that the level of work that member states on the council are dealing with is so incredibly high on sanctions. When sanctions were first created, when these tools were first put in place, we've seen just an extraordinary growth in the role of sanctions and how they're used by states, both through the council mechanisms and at national level. The result being, and I know Daniel maybe can speak to this in relation to individual member states, including particularly the elected 10 coming into this universe of work around sanctions and their fundamental inability to manage the workload, which also creates this additional issue around the legitimacy and kind of lawfulness of the process in a way. And the other point I would pick up from Daniel's remarks are to bear in mind that even though we are focused on counterterrorism sanction measures at the council, these are all often duplicated at national level. So what's happening is actually the individual is experiencing a double burden. They have the burden of what comes through listing on the council, but in parallel, they are also sanctioned or listed at the national level. And so even where the ombudsman is successful in delisting, actually these remain. The national lists often remain indefinitely, especially OFAC. And also even where, and we've had this, the mandate has had this engagement with governments where a person has been delisted from a national list, but they're still on an OFAC list somewhere. So that means they're still subject to these penalties, notwithstanding that a national, for example, judicial measure has found that they should no longer be on a list. It's sort of like something you literally can't lose it. So to go just to this question of thinking more forcefully around due process, I do want to say there's a quote of Daniel's that I'm going to quote as I think about this, which is he talks about the ways in which we've seen sanctions measures translate on a quote from a quote permanent tool of the UN global counterterrorism apparatus to more closely resembling a system of international law enforcement. Not a temporary political measure adopted by the Council with a view to averting an imminent threat to international peace and security. So we move from something that was intended to be exceptional and political to something that has become institutionalized in the DNA of the Security Council. But it's been institutionalized without a parallel level and commitment to due process protection. And it's happening simultaneously with the Council playing an ever-increasing, essentially quasi-legislative role in counterterrorism. So what we have seen from 2001 is the Council, uniquely in the counterterrorism space, behave like a legislator. And we're seeing it in multiple arenas, but they're behaving like a legislature without attention to due process and human rights. And it's clear the Council's space around counterterrorism was deliberately created to exclude a human rights perspective. The first chair of the Counterterrorism Committee, Sir Jeremy Greenstock, made it very clear when the CTC was established, this was not intended to be a human rights space. Human rights happens here, maybe Geneva, but it doesn't happen over there. And so we live with that institutional legacy. And so when we think about the sanctions piece, we have to see it in this broader architectural shift that's happened on the Council and the attendant lack of attention to human rights and to due process protections. I mean, just to say, you know, Daniel has made this point already, but when the Ombudsperson's office was created as a result of this protracted Bakadi legislation, it was very clear that that system had to respond to the deficits that the Kadi case had identified. And I think I have said and would stress it, the system is ripe for review, judicial review, because lawyers working in the system understand what they cannot get in the system and that it is functionally not Kadi compliant in terms of what Kadi demanded from states. So I would say if you're on the Security Council, beware of cases coming your way, because the situation is ripe for this kind of legal intervention, because the Council has failed to self-regulate. Because the Council, given the opportunity, which it had both through the Ombudsperson's report, through the reports of the Special Rapporteur, as well as other experts, has consistently failed to take the opportunity. And I think, as I think of Daniel's last report, some of the fixes are very simple, like the integrity and the independence of the Ombudsperson. That is actually not a hard thing to fix. It's not a political thing to fix, but there has been literally no political will to fix even that. And I think disappointingly, when we saw the renewal in December, not only did we see an unwillingness to fix really simple things, we also saw the opposite, which was an attempt by some states to further weaken the existing structure such as it is.
Yes, there was an attempt, a dangerous attempt with regard to the reversed veto system.
Yeah,
unanimity system,
exactly.
So consensus. The council, the committee has the right to overturn the recommendation, the ombudsperson, by unanimity.
Yeah.
And that is crucial.
Yeah,
that's
completely
crucial. Otherwise it wouldn't work.
Yeah.
And
so that gives us this insight into the sort of almost zero-sum game that we've come into, where there's this enormous power over individuals amassed. And I think the other thing for us to be aware of is twofold. One is that this is the only regime that has a mechanism. We have the proliferation of sanctions regimes with no mechanism. So we're only seeing one little needle in the thread, but we think of all of these other sanctions regime minus any kind of oversight mechanism and a complete resistance to putting one in place. We also see an increasing political pressure by states to put their favored individuals or entities onto sanctions. So one of the dynamics for new states, and again, without naming states, but new states coming on the council, many come on with the goal of having particular entities listed. And again, we go back to these sort of a priori problems, which is that the basis upon which that listing happens is in the shadow world of information and the shadow world of intelligence agencies and cooperation between states, which is also extremely shadowy in terms of the way in which data is moving from one state to the other and the kinds of protection or non-protection that's applying to that data. So it's this kind of bulge that we're seeing sanctions as a kind of an easy tool. And maybe to close on this thought around, why do due process protections matter? They matter because the sort of at the foundation of the rule of law is the idea of process, of being subject to knowing clearly what the legal basis for an action that will be taken against you in law as a kind of a fundamental foundational understanding of what a state or states can do, but also the very idea of fairness, that you have an opportunity to challenge a measure. And again, I just want to underscore, people think about sanctions like they're sort of less severe. Wouldn't it be worse if you ended up in jail? Wouldn't it be worse if you were subject to criminal sanction? But I think as both the Ombudsperson's reports and my reports have indicated over recent years, and my predecessors too, the consequences for the individual and their families are extraordinary. They are extraordinary. And in many cases, they have the impact that a criminal sanction might have on an individual, right? So the cumulative effect in ECHR terms would be, it functions almost like a deprivation of liberty, because if you can't work, if you can't travel, if you are also subject to administrative measures domestically, which many individuals sanctioned are, then they're in this universe of kind of, oh, sanctions is just one box, and then there are all these other overlapping boxes. And their capacity to function in society is completely undermined.
Maybe with regards to families, an example from my last case, Abdel Malik case, mentioned before. I had also an interview with his mother, and she told me, I'm very angry. I have to first some information. So Abdel Malik had a father. He is dead. He was killed in Syria. He was one of the founding members of Al-Nusra Front. So family ties to terrorism are obvious. He died 2014 when his son was convicted. His brother disappeared in Syria. Abdel Malik, the last of the family, back in his country together with his mother, and she told me, I lost my husband and 2 sons to terrorism. She said, to a culture of death and destruction, a cult of death and destruction. And now I am blocked together with my son and my daughter-in-law in an apartment, and we are completely isolated. And she was very angry about her husband, and she could explain that. But he was the reason why his family is where it is today. But she does understand that today it's a problem of the sanctions and no more of what was before. So she is angry about what her husband did, the father of her 2 sons. But now she's also angry about the fact that she can't move around because she is isolated. She is not accepted in her neighborhood.
No, it's a very good example, so, because it shows indeed what the effect can be on the relatives.
But it's also the idea that, again, the burden of punishment, if we think of sanctions as increasingly as a punishment, like it is a punishment, it then functions to have these other effects. And I take Daniel's point about often when we talk to people, we understand better. It is always amazing to me that we have these counter-terrorism measures that are kind of assumed to be effective simply because they exist, right?
Yeah.
But we have almost no independent measures of whether they function well or they don't. And more than that, we're not interested in tracking the negative effects of those that actually have the opposite impact, where they create communities and groups and individuals who are so separated out from society that even if we were to learn, and again, I think Daniel's point about the ways in which families understand what happened to them is extremely complex.
Yeah.
And some of the best, I want to say best, but some of the most powerful voices against these groups are family members who have internalized and understood the consequences to them from family members engaging in this violence, but we view them as inherently suspect, which compounds their challenges.
Indeed, yes. Let me now turn maybe to the renewals, because last year we have seen a number of renewals regarding the Ombudsperson position, but also regarding CTED. So maybe we'd start with you, Judge Kipfer. What did you think about the renewal of the position of Ombudsperson? Was it an easy process? Were there challenges, controversies? Are you happy with the results? What would you say?
I am happy as far as it was possible to save, to renew the most important aspects of the functioning Ombudsperson mechanism. And
so it's not over, it's still there.
It's still there, but it's on the threat. It will be again on the threat in 2.5 years, I'm sure. Again, it's for some countries, a few countries at least, it is a problem that the Ombudsperson has factual power. It's a limitation of the power of the members, and that they don't like it. Simply, they don't like it.
So there is stability, it remains the same, but no progresses whatsoever.
And that's the reason it was on the threat, and the US was the penholder in the renewal of the Ombudsperson mandate. They knew, and they didn't want to touch anything, because if they opened the Pandora box, maybe the result would be worse. So that was
like for treaties. Don't reopen the Geneva Convention.
But it is disappointing, as Fionnuala said before. Many of these issues would be resolvable by really tiny steps, and it's from a legal perspective, it's really difficult to understand why that is so important to protect the process from improvements. That's what it's. Why is that so important for some members? And my explanation for that is it's about power.
Yes,
it's not about due process and fairness. That are hurdles. It's they have to agree if maybe there would be a legal challenge visible. It's not for the moment, but it's possible, of course. But as long as it functions without, it's not necessary to improve fairness or due process or transparency, all of that. One example, I made a proposal last summer to go forward with the reasons letter analysis of the cases to share with petitioners.
Yes.
So that was always a problem in the past. I could establish some working method of confidence, of trust. So after 3 years, I had the members at the point where I could ask them for going one step further. And my proposal was not to share with petitioners, that's an aspect of the right to be heard with petitioners, a summary of reasons, but a redacted version, a visibly redacted version of the comprehensive report. So there are information in comprehensive reports not shareable with petitioners, I agree, but there is not a lot to redact. So visibly redacted, and it was surprising, committee accepted. So it was possible to create a new practice. And then for me, it was clear you have to build this, you have to find a new wording for the new resolution, accepting a change from analysis of the case to a redacted version of the comprehensive report to share with petitioners. It was not even possible to do that.
Oh.
So they do it now again. In these cases I was speaking about before, my successor is now sharing redacted version of comprehensive reports with first with the committee and then with the petitioner. I'm sure it will work, but it was not possible to change the wording. So not even that.
So pragmatic approaches are better, right? So it's
Yes,
easier to make
that was really
things change in practice.
Yes, change in practice,
integrating
but
that
then
in the mandate.
it was not possible to integrate it explicitly in the mandate, and that's really difficult to understand. Not even as an option. Also, that would have been possible to say there is an option for sharing redacted comprehensive reports instead of summary of reasons. But not even that. So the redacted version of comprehensive report doesn't exist in the new resolution.
I see. It's a very good example. And so, Special Rapporteur, what do you think about this? When you read this mandate renewal, what was your reaction and your analysis?
I mean, I was deeply disappointed. I suppose in part because I felt, and I think my team and our team here, we had worked very hard in the aftermath of the fall of Afghanistan. In particular, we felt that there was a political moment with the understanding of the effectiveness of sanctions. Clearly, one would fundamentally have to ask the really obvious question: after 20 years of 1267, did it work? I mean, at the global obvious level, of course it didn't work. We're right back, more or less, with some qualifiers, to where we were when these regimes were put in place, right? So that's like at a meta level, that kind of very fundamental question. I think we felt there might be an opportunity for states to actually raise that issue for themselves. And I think it was disappointing to see the ways in which, I think it was a particular opportunity for the US administration to show leadership as penholder on that resolution. But I think it's also clearly intertwined with domestic sanctions regimes, which are much more complex and a clear foreign policy tool used with great regularity by the United States. So this kind of international domestic interface actually has negative implications for the integrity of the international system when you have an overlap between a penholder who has other domestic interests at play. But I would say the system remains enormously vulnerable to legal challenge. So if we look at there was the Council of Europe Parliamentary Assembly report in 2007. We had the report of the eminent panel of jurists that followed, and then we had the CADI litigation. And all of them clearly say what the requirements of a minimal procedural standard needs to be in order to satisfy the requirements particularly in the European context and under those regimes. And we've also had jurisprudence from the European Court of Human Rights. So the NADA case, the Swiss case, also sets out and complements precisely these understandings of what, again, a minimal requirement would be in order for these mechanisms to be human rights and international law compliant. And I think not only in terms of the finding of breach in the NADA case, but the broader observation about what is required to have an effective remedy, and those are still absent, right? So an effective remedy, those minimal procedural requirements, the right to be notified, the right to be adequately heard, the right to enjoy the fundamental capacity to defend oneself, and the right to have a decision which affects one's fundamental right heard by an independent impartial body, and also the right to a remedy. So if we think about even the delisting that the ombudspersons have done, in cases, for example, of torture, it's very clear that there should be a right to a remedy for that individual, but also where people were wrongfully listed. Simply the wrong person or information which was manufactured or unreliable. So
no compensation whatsoever.
There's no system in place.
There is no compensation because it's not possible to challenge the initial listing decision.
Exactly.
It's Ombudsperson has the possibility to clarify the question whether the reasons are still in place today, but not back then.
So this is enormous in terms of the a sort of a legal one of the multiple legal black holes that we have seen emerge in the sort of counterterrorism architecture, and a legal black hole that's actually deepening. I mean, I think this is the point that 20 years out from the establishment of, and of course some of these mechanisms precede 9/11 in terms of 1267 and so on, but we're over 2 decades into these kinds of mechanisms. And in some ways, because they've grown and because the number of persons subject to them have grown, and the scale of the legal black hole continues to grow, not to get smaller, actually.
And what did you think about the seated renewal for the mandate of seated? Is it improving? New points that we should be aware of?
I think so. The mandate didn't comment publicly on the renewal, and I think we have a constructive working relationship with UNCTED, which has been very positive given the significance of the work that CTED does. I think what I have said publicly is that I remain profoundly concerned that the country reports that CTED undertakes remain non-public. Only one state has ever agreed to have its report public, Finland. And I think Finland should be commended, and Switzerland, but I don't think it's out yet. We haven't seen it yet. We have one that we have actually reviewed. But the idea that it's like another black box where you have these were public until 2006, and then they went into the black hole. And so, for a human rights body, if a state comes before a human rights body, it's public. We see what there is. And there's an appropriate role for redaction and information which is confidential. But the idea that that entire structure remains secret and we do not know what advice is being given to state, in my view, is fundamentally unacceptable. Because then we can't even measure. If I just had a country visit to Uzbekistan, everyone gets to see what the Special Rapporteur had to say about Uzbekistan, but we do not see what was good, and we don't know if the government is getting 2 different messages from 2 different UN entities. And as we know, if you have to choose between the message that you like and the message that you don't like, you're probably going to take the message you like. And so we were concerned, I think, that there wasn't a greater commitment to transparency. And the other 2 issues I would highlight on the CTED mandate that I think are of particular concern to the mandate is the increasing role that CTED and states have been proposing for CTED in relation to international humanitarian law. So it's clear that CTED in its country assessments, as it undertakes an assessment, should take on board a state's human rights and international law obligations broadly defined. But I will say that I have been really concerned about the possibility that there will be a primus inter partes situation in which CTED, as a special political mission in a highly sensitive context, that of counterterrorism, will be giving IHL determinations to states, particularly on status of conflict determinations. And as we know, states have no interest in having conflicts in their territories defined as being subject to international humanitarian law. They are much happier and more content when they can say this is a counterterrorism problem, not an IHL problem. And here's the set of rules we get to choose that we play within this sandbox. And I guess I would have profound concerns that this space becomes a space in which states essentially get a special political mission of the Security Council defining the status of conflict for them. And I think that has profound implications for the integrity of IHL, for the role of the ICRC, and more broadly, the kind of balance of who gets to be the interpretive voice on applicable IHL standards and how this space, CT-IHL space, will play out in the years ahead. And my very final point on this, the other piece of the resolution the mandate has been public on and concerned about, is the inclusion of battlefield evidence in the resolution. So the mandate has issued a public position on the use of battlefield evidence. But again, what we would say is that we see this as essentially a shortcut, the Security Council taking a shortcut around the weakening of due process standards by a Security Council resolution on CT. Bearing in mind that, again, states' national definitions of terrorism are extremely wide and extremely loose. So if you're saying to states you can use battlefield evidence in terrorism cases, in some countries that means cases that you take against civil society, journalists, people who simply disagree with you. And more broadly, the idea that we compromise due process protections through a Security Council resolution on trial provisions, I think is fundamentally at odds with an understanding of the agreed and appropriate limits of Security Council action. So those are my big concerns. On the positive, I will say the resolution did welcome CTED's role in working with civil society. That's a bonus. And I think, again, what we need is a kind of a limit in this space, not an expansion.
Great, thank you.
If I may go back to renewal of the Ombudsperson mandate, only for being clear about what regards the independence of the office. The office is not independent, or I have to say it in another way. There is no existing office of the Ombudsperson because it's not a UN body. There are two collaborators, a legal officer and an assistant, and there is an Ombudsperson as an external, with a mandate. And the office of the Ombudsperson is legally a fiction. So I worked on that for 3 years. So discussing with members, different members, with the committee, with UN representatives, also within the Secretariat. The field was prepared. The issue, the problem was accepted as an existing problem to resolve, but it was not possible to address it.
So. Incredible. Yeah. Let me now turn maybe to the last broad theme before we open to Q&A. You mentioned the Afghanistan Special Rapporteur, and we know that sanctions have been applied to the Taliban for many, many years now. Despite that fact, I mean, the Taliban are back in power. De facto, they are the government. So was it worth it? Maybe I'll ask you, Judge Kipfer, what do you think about that? Are these sanctions even acceptable if they don't work, apparently, because an armed group can then become again the government in place? So a question about effectiveness. And the second question, it's no debate, but in the past we used to say that it's a little bit acting, the Security Council is actually acting ultra virus, adopting these kind of sanctions, which in practice can be seen as even criminal sanctions because of the effects they have. So they don't work, apparently. Are they even legal? Can they even be acceptable? What do you think?
That's a difficult question. They didn't work. That's obvious. They didn't work at all. And in the context of my mandate, it's an irony of the entire evolution that I don't know if you know that. The targeted sanctions started with the Taliban, the listing of Taliban in 1999 and not with Al-Qaida. And
the
then
1267. The resolution 1267.
Taliban list. And 2001, 2003, then Al-Qaida members were added to the Taliban list. It was the Taliban and Al-Qaida sanctions list. And then there was, after the Qadi decision, the European Court of Justice, there was the discussion about the creation of a court, or at the end, the Ombudsperson. And one condition was not to include the Taliban on the Al-Qaida sanctions list, to split the two lists, because several countries didn't want that the Ombudsperson would have the power to decide about Taliban listings. It was a condition for the creation of the Office of the Ombudsperson to split the two lists in 2009. And one of the reasonings behind was, it was about power, as I said before, but one of the rational reasons given back then was we need the Taliban sanctions for as a leverage for political negotiations with the Taliban. So they had 10 years to use that leverage, and in the moment when US left, they were back immediately. It's also from this side, there was no use, no effect using Taliban listings as leverage in political negotiations. Zero, nothing. And that's it's a little embarrassing.
Yes, it is. Yeah, that's true. Yeah.
And now we have about 80 to 100 listed Talibans back in power.
Yeah.
And there is now a problem with how can we collaborate with listed Talibans?
Yeah.
And we would have to because of humanitarian.
Well, that's the question of the day in a way.
Yeah, but you are not allowed.
Yeah. Yeah, I mean, I would say the broader question of the effectiveness of counterterrorism sanctions regimes, which I know is a project that the Academy is running at the moment, and Gloria is leading and thinking more broadly about these questions, is a fundamental and obvious question. Does it work? And what evidence do you have along the way? And I think many of us would observe a disproportionate emphasis on kind of what you might call the kind of affirmative process of creating outputs with very little reflection on the question of what evidence do you have, does it work, and how do you adjust them if they're not. There's a broader disinterest in the global counterterrorism space on monitoring and evaluation, those two quite boring words, monitoring and evaluation, because I don't think fundamentally there's an interest in knowing. There's a performative action aspect to the kind of ways in which counterterrorism practice has emerged over the last 20 years that makes that question irrelevant, because there's a performativity to the action of engaging in more and more CT measures, and we've seen that in multiple resolutions from the Security Council from 2001 onwards. I think what I would just say, make some observations on some of the resolutions that we saw this in the autumn. I mean, and in December in particular, there was an extraordinary opportunity after August to have a conversation about this, whether it's working or not, and what's our vision for counterterrorism practice 20 years on. And I think what's really depressing is that we haven't seen any willingness to engage in a more thoughtful or necessary conversation about it. And that's particularly regretful in the context of the large-scale systemic abuse of counterterrorism measures at the national level. Bearing in mind that so many states are essentially governing by counterterrorism, they're governing by security. And this rise that we see in authoritarianism and democracy backsliding is not unconnected to the growth of the global counterterrorism architectures and practice after 9/11. And I think there's a profound unwillingness to see those connections. But if we look at, again, specifically at some of the resolutions, so the Ombudsman resolution essentially stays the same. The opportunity was not taken to do the kind of hard, not even hard work. Some of it was not so hard. Some of it was simply a question of not even mobilizing political will, but mobilizing effective effort to just fix some things that were broken. I think if we look at the 2611 resolution, which is the monitoring team on Afghanistan, and really another important resolution, that resolution did not address any of the expansive need for further monitoring, particularly on violation of women and girls' rights in the context of the discussions we've been having with the emergence of the de facto authorities and the concern that everyone says they have about the protection of women and girls, but we don't correspond that into the monitoring team's work. And so that's yet another signal. And then we had resolution 2615, which is, enables this in that resolution. The resolution does address humanitarian aid to Afghanistan through the inclusion, a decision that, quote, humanitarian assistance and other activities that support basic human needs in Afghanistan and are not in violation of paragraph 1 of resolution 2255 would be allowed. But let's understand what that is. That's a one-year resolution in the context of a profound humanitarian crisis that will not be solved in 1 year, that has deep and sustained roots. And that also essentially, and I think this is what worries me the most, makes the gift of humanitarian action a gift of the Security Council rather than a recognition of the legal requirement to allow impartial humanitarian action in situations of armed conflict. So we've moved to these things being gifts of the Security Council, negotiated in complex political settings where states will, for many reasons, dispute the value of the gift or the necessity for it, and conceded the position of principle, which is that in a situation of armed conflict, impartial humanitarian activities should be carried out. And that's where I think we have to move the fight back to, which is not to say this is in the gift of a particular Security Council resolution to give, but that it's customary international law and protected by the conventions. And this is the basis on which we have the argument, not in the context of a fraught counter-terrorism negotiation on a particular mandate. And in 1 year's time, we're going to be right back where we were on deciding with the humanitarian crisis we are still having in Afghanistan. And we will be back to having the fight about whether we're going to extend a humanitarian exemption for the specific context in Afghanistan. And we've solved nothing in between. And to Daniel's point about, the unpalatability of the situation we're in, and where the counterterrorism measures are directly impinging on the capacity to deliver humanitarian assistance, and the kind of gymnastics we're seeing happening about who do we work with and who do we don't, who's on the list, who's not on the list. And that doesn't undercut the unpalatability of doing business with the Taliban. But let's be clear, some states were prepared to go into a Doha agreement and sign a deal with them and not ensure that these things and the annexes to those deals have not been made public. So we don't even know. So we can do a deal in this space, but we cannot protect the fundamental right to humanitarian action on the Security Council. And I think just this tells us the zero-sum game of counterterrorism over the last 20 years. It tells us that we're in a zero-sum game. And I will say that no one should be naive about the notion that counterterrorism is entrenching, it's consolidating, it's expanding, it's not going away, and it's also growing within the UN system. We now have an Office of Counterterrorism that has, 158 at last count bodies, and one unpaid special rapporteur in New York, who again, by the will of states, is the only entity currently in place to oversee the interface between counterterrorism and human rights in the global system. And that is not adequate. It is not enough, given the scale and the scope of the growth and the consolidation and the entrenchment of counterterrorism over the past 2 decades.
Yeah, thank you very much. I have a follow-up question regarding Afghanistan and the humanitarian exemption. Often there is this idea that it's impossible to provide humanitarian aid in such contexts because then you have diversion. So you provide humanitarian aid to civilians, but then it will end up in the hands of the combatants and the fighters. And so what do you think about this argument of diversion?
So, it's a good question to ask, and states always ask the question. And I think we do accept that there's always a degree of diversion. But the conversation I'm really interested in having with states around this is, let's look at the universe in which states are often equipping multiple actors, including the state, in these conflict or counterterrorism contexts. And the issue the mandate has been looking closely at is another kind of diversion, which is the diversion out of state security assistance and technical capacity building directly into the arms of non-state actors. So, I mean, Afghanistan is a beautiful example where, I don't know, we left them a lot of stuff, let's just say, but also if we look at other states where counterterrorism capacity building is going into states who have poor and limited oversight on their security sector, the diversion issue is a diversion out of the state's support for counterterrorism into non-state actors. And I mean, we haven't got there yet, but maybe before in the next couple of in the next year or two before I'm done, let's talk. So if we want to have a conversation about diversion, let's have that conversation, but let's have the two pieces of the diversion conversation on the table at the same time. And I think I'd be pretty willing to bet that the diversion out of ill-equipped, security sectors that are bloated and inadequately overseen, that the diversion into non-state actor coppers and structures is far higher than it is out of sending aid to humanitarians or other impartial actors on the ground. I think we're talking about night and day, and that's the diversion conversation we should be having.
Excellent point. Yes, thank you very much. A very last question, which is really to broaden the debate. You are lawyers, international lawyers, judges. How is it to be confronted to diplomats, to specialists of counterterrorism? Is there a kind of shock of culture? And how did you cope with that? When did you feel that your messages went through? And what were the strategies you used to convince? Same question to both of you.
Different questions. For me, yes, it was a kind of cultural shock when arriving within UN context, counterterrorism context, and especially my committee, the 15 members of the 1267 committee. I was shocked, surprised about the fact that I had to work on legal issues in a context, in an environment where nobody was thinking in the same categories as I had to. So that was surprising. I didn't even was aware from the beginning. It took some time. At the beginning, I was sure to talk in the same language to my to the members of the committee, but with time I began to understand that there is a complete difference between two cultures. To be in a mandate with a quasi-judicial function and to argue, to discuss these cases with persons not really interested in legal discussions and often not even understanding what I was talking about. Yes, how to cope with that? To insist. To insist on legal rationality, to repeat always the same reasonings. There is another problem within UN and Security Council and members of the committee. After 14 months, when I started with my mandate, 14 or 15 members, persons representing their countries in the committee were new. So I had to start all over again. And there was no real progress. That's, but as I said before, the recommendation of the Ombudsperson is very strong. So even if they didn't accept, they had to.
So that's a great result. Thank you. Special Rapporteur, you have the last word.
I mean, I think for every new Special Rapporteur, you know, Philip Alston, who's an old friend of mine when I became Special Rapporteur, and had given me advice when I started, said, you have no idea what this is going to be like. I could tell you, but you actually won't know. I think that's true for both of us. I will say that the biggest shift for me as an academic and as a person who had worked in civil society settings, I'd served on our National Human Rights Institution, I'd served as an ad hoc judge. I think the biggest difference was to occupy the space, which is a legal space. The strength of this mandate is its legal work and the incredible team of lawyers at the back of the room who enable the legal work, who work with me. But it is about also understanding your diplomat. You have this quasi role of engagement with states, which is about building relationships of trust. And I think for me in particular, priority was, I said, this was to move outside of the traditional relationships with primarily Western and other states, and to build relationships with states in every single region. And that has really been a priority for the mandate, to try to really broaden a much wider conversation around counterterrorism to include a much larger number of states. And some of the benefits of that, I think we saw in the Global Counterterrorism Strategy Review process, where I think the work was showing results, not only in terms of support for the mandate, but really that in quiet ways, through many, many conversations reiterated over time, we had built support around particular issues that wasn't there before. I think the other thing I would say about the culture shock, which is different, is a Special Rapporteur is part-time. And I think one of the particular demands of this mandate is this New York Geneva interface. And human rights is not generally welcome in New York. That is the reality. The space for a human rights conversation is so narrow. And so I think we've had to fight for every inch of space we get there. And I think the other thing the mandate has committed to is not just opening the space for UN special procedures, but also to civil society. So a core goal for me is not to create space just for special experts, but actually to create space for civil society and governments to hear directly from civil society. And the reason for that is that the counterterrorism policy we have is not fit for practice, and it's not working. In so many states where there are serious problems of violence and terrorism, the policies we have crafted are not doing the work to prevent and end conflict and violence. And the only way you're going to know that is if you listen to the people who are the subject of the measures. And we do not have that space in New York. So states are very happy for us, for civil society to show up here in Geneva. It's great. But actually on the security side, we have to create space for those conversations in New York. And so the culture shock is that it doesn't exist. And I hope what the mandate has been helping to do in the last couple of years is actually crack open a slightly wider space for that conversation to happen.
Excellent. Thank you very much for sharing your thoughts, your experience, your analysis. That was tremendous. Thank you. I think we can clap. So before I open to the Q&A, would you like to
Yes,
add
I would
something?
like to add an example about cultural difference between politics and justice. I had to understand that for the members of the committee, it is about participation in a political process, also about decisions about listing or delisting cases. So they insist on their right to participate as a member and to give the opinion we are opposed or we agree or different. But for me, it was striking to see that often countries giving their opinion do not feel obliged to give reasons for that. So only saying we are opposed, we do not agree with the recommendation of the Ombudsperson, but without telling me why. And in a judicial proceeding, that's impossible. If you go to a judge saying, I do not agree, then he will ask you, so why do you that? And if you don't give an answer to that, the judge will answer to you, that's not relevant to you. And it's about participation. It's about to give the opinion, to have a vote. That's politics, and it's not about reasons at the basis of the discussion. So symbolically, I had to present my my comprehensive reports to the committee. There was a possibility for asking questions to me or giving comments. Normally 1, 2, or 0. And then I had to leave the committee meeting, and then my report was discussed without me. And, and sometimes I got information about that discussion with questions or critical remarks informally, critical remarks which would have been easily to respond to for me, but they didn't ask me. So I was not welcome for the discussion of my reports. So it's not about the content, it's about the decision.
So there is really a need to push always the envelope, to be present, to make one's voice heard. Great. We can now open to questions. So people obviously in the room can raise their hands, and then online there is also a possibility to ask questions. We have a chat, so you can use the chat function. Do we start with the chat maybe? Because I see that we have already questions here. So I'll start with the first question, which was asked by Issa Toussa. Anticipating emerging threats is crucial to the prevention of future attacks. What are the global strategies in understanding the evolution of terrorism rebellion? Who would like to take that?
I can take that.
This is more on terrorism.
Yeah, I mean, so I think we have, we have the annual Global Counter-Terrorism Index, which is issued once a year, which is a very useful tool in assessing, I think, global trends. I think it's important to note, actually, counter-terrorism trends, terrorism overall has been falling. So the number, if we look at those global numbers in recent years, there's a significant fall in overall threat. The second thing is, it's been really clear, I think, that we've seen an emergence of, in particular, what we might call right-wing related violence. There's different terminologies to describe what that phenomena is. The United States uses the REN-V phase, others use different kinds of terminologies, but the emergence of new forms and manifestations of terrorism, I think, is clearly indicated in the index. And I think the other trend is, in terms of, I want to say I'm a skeptic somewhat on this language of threat, because lots of things are threats to society. And the idea that we put all kinds of threats of violence into the terrorism box, which is in fact the trend we're seeing, I think is one that is profoundly problematic from a rule of law and a human rights perspective. And terrorism is an easy box for states, because the ways in which that degree of latitude that states have under the frameworks, whether they're global or national, give enormous capacity to states to use the coercive power of the state against those who disagree with them, those who criticize them, those who are engaged in different kinds of political activities that the state doesn't want to occur. So we've seen this in multiple countries. The mandate has commented on most of them in the last year or two, and or since I took a post. So I think one of the challenges is this. To me, the more fruitful conversation in this space is actually the conditions conducive conversation than the anticipation of threat. Meaning, if you are seriously thinking about the conditions that produce violence in a society, then you will understand the kinds of things you need to do to engage in prevention of that violence. And often those involve engaging structures of inequality, structures of discrimination, structures of unequal treatment. And the best report I would recommend in this regard is the UNDP report on pathways to extremism in Africa, one of the most comprehensive studies on the kinds of things that produce the conditions conducive to violence and terrorism. And so from the mandate's perspective, I think really firmly focusing on that space actually helps us be in the business of prevention rather than in the business of dealing with the aftermath.
So thank you.
From my perspective as a criminal judge, I can confirm that dealing with threats is a problem also for criminal law. And I would like to focus your attention on the following. It's one question to impose a preventative measure for guaranteeing security. Criminal law, it's possible measures for, that's one question. It's much more difficult to remove an existing sanction or measure, because then you are responsible for taking away a measure protecting society. You could be possibly responsible for a problematic outcome. But if you don't impose it, it doesn't weigh so deep. It's not so important. So it's much more difficult to remove existing measures than not to impose them. And that it's very important for all these discussions. I think the day you have imposed, you have created preventative measures for protecting security, you will have to have good reasons to remove them. So maybe it's more important to be critical about the decision of imposing them. So
that's true.
I hope you do understand what I mean.
Yes, definitely.
So
thank you. Do we want to take a question here? Yes.
Hello, thank you so much. I have actually two questions. One is more about the impression that I had when I was studying the Sanctions Committee of the fact that it was a product of the US and the Western countries, like some of the European countries. So I was wondering, and I was curious about the impact and the position of other regions in the world, like whether they were, like their behavior towards the sanction based in general to the architecture and the impact that it had on it. Because then terrorism is a large part. Sometimes we speak a lot about the jihadist terrorism, or there are a lot of forms of it. And the second one, like we spoke a lot about the fact that the terrorist box is a really large box, and it's always used also to stretch the rules of human rights and to violate in case like the obligation that the state has towards human rights. So I was wondering if you see also dependency in the armed conflict. So if there is a stretch of rules of humanitarian law when states are engaged in armed conflict against a group that is a weak state. Thank you.
Do you want to take the first one?
it's
Don't bite.
No, we never. Our office is very simple. One of the bonuses of the work has been working with Daniel's office and his team over the last couple of years. Maybe just to say on them, I think while there have clearly been states who have had an outsized interest and have a corresponding domestic practice in relation to sanctions that is kind of outside other states, I think we see a significant investment by many states in the sanctions system. And I'd be interested to hear Daniel's reflections on that. But my observation would be very much that it is part of the challenge of undoing it is the kind of significant buy-in we've had from states. And some of that is pressure, I would say, that there's significant pressure on states to maintain the system as it stands and not undo it, but also because states are increasingly using sanctions at the domestic level. So even if these people are not ending up on UN designated sanctions lists as entities or individuals, states have spotted the value of sanctions and listing. So many of the countries of Special Rapporteur that I visit, all of them have sanctions or listing procedures. Many of those individuals will never end up on a UN. That's the dynamics of that are not likely to happen. But the existence of these global sanctions give cover and legitimacy to the use of the processes domestically, which is why I see the value of defending them globally.
Well, my experience is not broad enough for really responding to that. In my proceedings, I had only first designations from US or from European countries and not from other countries. So I know that there are existing terrorist lists, for example, also in many Middle East states. I know that. And sometimes there are UN listed persons as a reflection of the UN listing also on the national lists by decisions of courts, and additional reasons sometimes that happens. But what regards the politics from other countries, my experience from my cases is not broad enough. So
I have a question also from you, from the chat. It's someone you might know, Caitlin Chandler.
maybe.
Daniel, is it possible to explain why the US is able to list someone only due to intelligence and not any other process? Has the UN taken this up with the US government in terms of asking for changes? Also, what is the listing procedure for non-European US countries, which is a little bit closer? And finally, how long does it take for someone to be delisted? Is this procedure quick enough given the people in questions have their lives on pause?
This last question, that's important. As I said before, I have two crucial mechanisms in Ombudsperson's proceedings. First is the reversed veto system, so unanimity is required for overturning the recommendation. The second are the absolute timelines. So the answer to the last question is about a year from starting the procedure to the decision of the committee, between 10 months and 14 months, and then it's done. So that's a guarantee if there is an ombudsperson in office. So that's but this time it was possible to appoint a new one quickly. So the first question, what
so
regards
like
US listings, for US, it is a condition to agree to UN listings, 1267 committee listings, a condition for agreeing to that the person is listed before on a national list. And there are legal requirements for that. And there are also courts deciding about whether a person on the OFAC list has to stay there or has to be removed. So the legal guarantees from United States law are implemented in that condition. The condition to be listed on the national list before UN listing can be accepted by US.
I think the other thing we would just say, at a national level, we see enormous deference by national courts to listing in general. I mean, so I think one of the challenges is that and that also correlates to some of the emerging presumptions around the kinds of evidence. So one of the mandate's significant concerns is the increasing use of intelligence evidence in multiple forms in national level proceedings. We see them in immigration proceedings related to security deportations. We see them in administrative proceedings, so administrative law proceedings, And we also see them in these listing procedures, so that again, the individual is not, the fact that it happens in a national procedure doesn't mean that the individual has better access to evidence. Often not. And I think this broad deference of national courts to national security framings is one that predates the events of 9/11, but has consolidated and deepened since that time.
Thank you.
And what regards US, OFAC has to be prepared to fight against the legal challenge in a court. So they have to prepare sufficient information for a possible legal challenge in court.
I see. Sure.
That's what I heard from US. Yeah.
Great, thank you very much. Do we have a question in the room? Yes.
Just something that you mentioned before, kind of, I've been thinking on quite a bit. You said some of the fixes are very simple. And as we've been looking through how to approach this idea of effectiveness and measuring the effectiveness of counterterrorism measures, when you go to academics and experts, they say, oh, well, it's a very complex matter because there's all these interaction effects that you have to account for and everything. And then and even with practitioners at the state level, they say, well, that's a very complex issue. It's very difficult. And then you look at, for instance, the Netherlands, where they one of the few states that has made efforts to measure some of their policies and laws. And it's sometimes very simple things that they look at, like who's being arrested for this? Is it being applied correctly? And they, can either determine at least some degree of effectiveness, maybe not an effect size or something very scientific to that standard. But so it makes me think, sometimes are we complexifying these things too much? And I just wanted to hear your opinion on this as far as, do you think that there's many of these complex issues that could be maybe resolved in simple ways? And, do you think that maybe this is kind of a symptom of the power dynamics that, you mentioned throughout your talk, as far as maybe states don't want to cede power. So this is one of the ways that they can do it by saying, oh, these are too complex of issues.
I mean, I would say there's a distinction to be made between complexity as a political matter and complexity as a legal matter. And so certainly in relation to the fixes, let's say, that were proposed in relation to the Ombudsperson's independence is a good example. These are really simple, or the budget of the Ombudsman, or the having a laissez-passer to go from A to B. I mean, these are simple things. They're administrative functions. But even at the national level, I would say, like, one of the reasons why the mandate has consistently argued at the national level and at the global level for independent oversight of counterterrorism, which is very simple. I mean, I say that coming from a jurisdiction that had 30 years of independent oversight through the height of the conflict in Northern Ireland. There was always an independent oversight of counterterrorism, and some states have been able to put that in place very effectively. And that mechanism alone, I'm saying, you have to have a legal process to establish independence, and it has to be independent and it has to be adequately resourced. But then once you have that in place, that mechanism then creates a way in which the kind of information, whether it's statistics, whether it's measuring effects through engaging with affected communities, whether it's about looking at legislation and understanding legislative pathways, those are all things that lawyers know how to do really well. It's not rocket science, actually. And that's really the point, that it is really not rocket science. And I think in this regard, also the mandate's really significant case for independent oversight of UN counterterrorism is made, given the significance of ensuring that we have the same kind of oversight that we argue should be applied to national counterterrorism work, that the states should be holding the UN accountable for the way it does counterterrorism, because that is a significant part of this equation. And the absence of that oversight is an enormous and compounding problem to some of the national level issues we're seeing. So I mean, this has been my call to states, which is hold the UN itself accountable for the counterterrorism work that has been growing, consolidating, and deepening within the UN system for the past 20 years, because it's your money they're spending. So you might want to know what's happening. Yeah.
Thank you. I have an interesting question from Gavin Sullivan.
Yeah.
He said, thank you for your candid account, Daniel, and your work in the role. You have worked as a judge in the Swiss court and as a UN ombudsperson. Could you discuss the key differences in your experience between a judicial due process and the delisting process? What are the key procedural reforms that might improve the delisting process? Will the powers the ombudsperson now has likely remain, or will listing states likely take greater powers back to overturn the ombudsperson's decisions?
Last question, yes, Gavin Sullivan. I know him. Thank you, Gavin. And maybe not all your questions are to. I maybe can't answer to all your questions here in that space, but I would like to do it with you personally.
It will stay confidential.
But what regards your last question remark, as it was said before, I think the mandate and there are threats. There are threats, there's no question, but I'm slightly optimistic that we will be able to protect what we have right now. But I'm not sure if I'm hearing Fionnuala speaking about broader perspectives. What is about the differences between a judicial review process and the listing process? There are, for example, different roles for lawyers that maybe could be interesting for you. I would like to discuss that with you. For example, if I am in a criminal proceeding, an indicted person has procedural rights, but not only indicted persons, also there are experts, there are witnesses, all of that. In my proceedings as an ombudsperson, I do not have any formal roles, not even for lawyers. So lawyers are assisting petitioners. I'm very grateful, Gavin, you did it pro bono. It was really great work from your side, but I couldn't change the fact that in the listing process, there is a big lack of formal responsibilities and of formal roles. That means that the entire proceeding is based on the trustworthiness of the ombudsperson. So it's really on the person itself to be credible, to demonstrate fairness within the possibilities of a more or less informal process. So, and what is important here also is the role of the petitioners. It's much more about the credibility of petitioners and about what he speaks, and it's less about the lack or the availability of evidence in a legal sense. So that's maybe difficult to understand, difficult to accept for a lawyer, for a criminal defender, as he is. But that is the basis on which the ombudsperson has to work. I hope that.
I think you answered his questions. Thank you very much.
Okay.
I have one more question for you, Special Rapporteur, which is more on humanitarian exemptions.
Yes.
And so whether this is a sufficient solution, maybe we should have further solutions to make sure that humanitarian action can take place despite all these sanctions. So what kind of mitigations we can imagine?
Well, our position paper, which is out, and I recommend to those who we argue this position much more comprehensively. But it is the mandate's unequivocal position that we start from the principled position, which is that the protection of impartial humanitarian action follows not as a gift from counterterrorism, as I said before, but as a foundational customary international law principle protected also by the treaty law. And I think we recognize the existence of exemptions, and our position is that they should be standard practice in all sanctions regimes. It is, I think, particularly challenging to see that we've had some progress on certain sanctions regimes with very particular political contexts to enable that, but that it's not standard practice. It starts as a negotiation on every single regime to include an exemption, and we see the differences. And my senior legal advisor, Megan Mannion, is at the back and knows these inside out better than I do, in terms of the kind of negotiation over particular kinds of language on specific resolutions. We don't have the standard acceptance that these exemptions should be there. I think the mandate's further position has been really clearly that licensing is a problem. So we've seen this practice of issuing licenses. And again, I think we would have a principled objection to those licenses, not least because both the potential for arbitrariness in the issuance of those licenses, as well as the interpretations. We saw this when the US issued specific licenses in relation to the provision of humanitarian aid and goods in Afghanistan. Even among experts, there was a discussion as to what the language of the license meant in order to not run afoul of the sanctions regime. And again, I think the challenge of licenses is that it has these downstream effects, particularly on humanitarian actors. We see it concretized in things like the kinds of large-scale humanitarians and the contracts they have with states, where we see essentially the devolution of risk. So what happens is the risk isn't being taken by the state given the license. It's essentially devolved to the actor on the ground, the humanitarian actor on the ground, and the burden on that actor to meet the conditions, often through contract stipulations, is extremely high, and often means that in practice it's unworkable or extremely high risk for those actors to do the work that they're doing even under license. So again, as we think about the unfolding humanitarian catastrophe in Afghanistan, which the scale of the harm that the Afghan people are experiencing at this time, that more children will die in Afghanistan from sanctions than have been killed in the conflict, we should then really seriously think about where's the greater harm coming from? Is it coming from the sanctions regimes, or is it coming from the armed conflict, which we saw play out over the last decades? And if it's coming from the sanctions regime, then it is the international community which bears the responsibility for the harm, not the actors in situ.
Excellent. Thank you very much. So if there is no more burning question, I'm going to close this event. I would like to thank our panelists. I learned really a lot during these discussions. I appreciated the fact that you really shared very candidly your thoughts and opinions with us. So thank you very much. Thank you.